Hi, I am Leslie. I will be discussing about Writ of Habeas data. Come and join me. But before we go to the very principle of habeas data, let's talk about some of its background first. AM 08-1-16-SC, or the Rule on Habeas Data, took effect on February 2, 2008 following its publication on a 3 newspaper of general circulation. It was conceived as a response given the lack of effective and available remedies to address extraordinary rise number of killings and enforced disappearances. It was conceptualized as a judicial remedy enforcing right to privacy, most especially the right to informational privacy of individuals. As defined, the right to informational privacy of individuals is the right to control the collection, maintenance, use, and dissemination of data about oneself. So, what is habeas data? Habeas data literally means that you have the data. The writ of habeas data is a remedy available to any person whose right to privacy in life, liberty, or security is violated or threatened by unlawful act or omission of a public official or employee or of a private individual or entity engaged in the gathering, collecting, or storing of data or information regarding the person, family, home, and correspondence of the aggrieved party. It is an independent and summary remedy designed to protect the image, privacy, honor, information, and freedom of information of an individual and to provide a forum to enforce one's right to the truth and informational privacy. Who may file? Any aggrieved party may file a petition for writ of habeas data. However, a representative may file in cases of extra-legal killings and enforced disappearances. In such cases, the petition may be filed by A. Any member of the immediate family of the aggrieved party, namely the spouse, children, and parents. Or B. Any ascendant, descendant, or collateral relative of the aggrieved party within the fourth civil degree of consanguinity or affinity in default of those mentioned in the preceding paragraph. Where should a petition be filed? At the option of the petitioner, the petition may be filed before the regional trial court where the petitioner or respondent resides, or 2. which have jurisdiction over the place where the data or information is gathered, collected, or stored. But when the action concerns public data files of the government, the petition may be filed with A. the Supreme Court, or B. the Court of Appeals, or C. the Sandigan Bayan. Where returnable or enforceable? When the writ is issued by a regional trial court or any judge thereof, it shall be returnable before such court or judge. When the writ is issued by the Court of Appeals or the Sandigan Bayan or any its justices, it may be returnable 1. before such court or any justice thereof, or 2. to any regional trial court of the place where the petitioner or respondent resides or which has jurisdiction over the place where the data or information is gathered, collected, or stored. When issued by the Supreme Court or any of its justices, it may be returnable to 1. before such court or any justice thereof, or 2. before the Court of Appeals or the Sandigan Bayan or any of its justices, or 3. to any regional trial court of A. the place where the petitioner or respondent resides, or B. that which has jurisdiction over the place where the data or information is gathered, collected, or stored. Take note that the writ of habeas data shall be enforceable anywhere in the Philippines. How about the docket fees? Docket and other lawful fees shall not be required from an indigent petitioner. Also, the petition of an indigent shall be docketed and acted upon immediately without prejudice to subsequent submission of proof of indigency not later than 15 days from the filing of the petition. What should be the content of the petition? The petition must contain the following: A. Personal circumstances of the petitioner and the respondent. B. The manner the right to privacy is violated or threatened and how it affects the right to life, liberty, or security of the aggrieved party. C. The actions and recourses taken by the petitioner to secure the data or information. D. The location of the files, registers, or databases, the government office, and the person in charge, in possession, or in control of the data or information, if known. E. The reliefs prayed for, which may include the updating, rectification, suppression, or destruction of the database or information or files kept by the respondent. In case of threats, the relief may include the prayer for an order enjoining the act complained of. And F. Such other relevant reliefs as are just and equitable. The petition must adequately show that there exists a nexus or connection between the right to privacy in one hand and the right to life, liberty, or security on the other. The allegations in the petition must be supported by substantial evidence showing an actual or threatened violation of the right to privacy in the life, liberty, or security of the victim. Bear in mind that the writ of habeas data will not be issued to protect purely property or commercial concerns, nor when the grounds invoked in the support of the petitions therefore are vague and doubtful. Issuance of the writ. Upon the filing of the petition, the court, the justice or judge, shall immediately order the issuance of the writ if on its face it ought to issue. The clerk of court shall then issue the writ under the seal of the court and cause it to be served within 3 days from the issuance, or in case of urgent necessity, the justice or judge may issue the writ under his or her own hand and may deputize an officer or person to serve it. The writ shall also set the date and time for summary hearing of the petition, which shall not be later than 10 days from the date of its issuance. Refusal to issue or serve the writ is punishable for contempt of court. Also, a clerk of court who refuses to issue the writ after its allowance or deputized person who refuses to serve the same shall be punished by the court, justice, or judge for contempt without prejudice to other disciplinary actions. Service of the writ. The writs shall be served upon the respondent by a judicial officer or by a person deputized by the court, justice, or judge who shall retain a copy on which to make a return of service. In case the writ cannot be served personally in the respondent, the rules on substituted service shall apply. So, what about filing of a verified written return of writ? What are the contents of return of the writ? Well, the respondent shall file a verified written return together with supporting affidavits within 5 working days from the service of the writ, which period may be reasonably extended by the court for justifiable reasons. The return shall, among other things, contain the following: A. The lawful defenses such as national security, state secrets, privileged communications, or confidentiality of the
source of information of media, and others. B. In case the respondent in charge, in possession, or in control of the data or information subject of the petition, a disclosure of the data or information about the petitioner, the nature of such data or information, and the purpose of its collection. The steps or actions taken by the respondent to ensure the security and confidentiality of the data or information, and the currency and accuracy of the data or information held, and other allegations relevant to the resolution of the proceedings. Remember, a general denial of allegations in the petition is not allowed or permitted. Now, the question is, who will be punished for contempt? The court, justice, or judge may punish the following with imprisonment or fine. A. A respondent who commits contempt by making a false return. B. A respondent who commits contempt by refusing to make a return. Or C. Any person who otherwise disobeys or rescists the lawful process or order of the court. Any party may appeal from the final judgment or order of the Supreme Court under Rule 45 of the Rules of Court, raising questions of fact or law or both. The period of appeal shall be 5 days from the date of notice of the judgment or final order. The appeal shall be given the same priority as in habeas corpus and amparo cases. Institution of separate action. The filing of separate criminal, civil, or administrative actions is not precluded by the filing of a petition for the writ of habeas data. When a criminal action has been commenced, no separate petition for the writ shall be filed. The relief under the writ shall be available to an aggrieved party in the criminal case. So, that's all about writ of habeas data. Thank you for watching.